Have two, we only have 5 more to go. Now, a lot of the material in the balance of this is, you know, the notices, we'll look at the notices, supporting documentation. But still important. So just take a sigh. You've been through, I think, what is the most complicated section of it all. That's why it took quite a while to get through that. All right, so we're going to look at section 2, which is certification and notices. And first page there talks to the certification for leave. If you go to that first full paragraph, in most cases, the employer should request an employee furnish certification at the time the employee provides notice of the leave, or within how many days? 5 business days thereafter. In the case of unforeseen leave, the employer should request certification within 5 days after the leave commences. An employer may request certification at some later date if the employer has reason to request the appropriateness of the leave during the duration, or its duration. An employee is required to provide the requested certification to the employer within how many days?
15.
They're going to get it back to you 15 calendar days after the employer's request, unless it's not practicable under the particular circumstances to do so. Despite their efforts, good faith efforts of the employer, and it provides more than 15 days to return the certification. All right, so you get it back. What happens if it's not complete? So this is talking about what would happen there. Complete and sufficient certification. The employees must provide complete and sufficient to the employer. After the employee provides certification, it is the employer's responsibility to advise the employee if it's incomplete or insufficient. And go 2 lines down. A certification is incomplete if the employer receives a certification but one or more of the entries has not been completed. It is insufficient if the employer receives it, but the information provided is vague, ambiguous, or non-responsive. Okay? So at that point, really, anything else that needs to be gathered should come through the employee, not you. Okay? You should really, as much as possible, get that through the employee. And of course, we'll talk a little bit about some second and third opinions here. The employer must provide the employee 7 calendar days to cure any deficiency. So you got it back, it was insufficient or incomplete, you give it back, they have 7 more days to clarify that. Okay? Now the last line of that same paragraph, a certification that is not returned to the employer is not considered incomplete or insufficient, but constitutes a failure to provide certification. If they never got it back, it's neither incomplete or insufficient. You just didn't get it. So in that case, when you're not getting certification, are they endangering their FMLA rights? Absolutely. Absolutely. That's part of the process. And you'll see at the bottom there, failure to provide adequate certification. When an employer requests a clarification or certification, the employer must advise the employee of the consequences. It goes on to say if the employee fails to provide it, the employer, next page, the employer may deny the FMLA leave. This is part of the process. Okay. Then the next section there, medical certification for a serious health condition. I'm not going to read all that. We will we'll talk about the form in a minute. At the bottom of that page there, the Department of Labor has developed 2 optional forms, E and F. Now, WH-380E stands for what? E stands for employee. WH-380F, F stands for family, for a family member. Okay? And there are more, but those are your 2 predominant ones. Okay? Talks about what is a healthcare provider. The next page, authentication and clarification. If the employee substitutes a complete and sufficient certification signed by the healthcare provider, the employer may not request additional information from the provider. However, the employer may contact the provider for purposes of clarification and authentication. Okay, after the employer has given the employee an opportunity to cure. The employer must use one of the following: a healthcare provider, an HR professional, a leave administrator, or a management official. So the purpose here is that you need to understand it, and just kind of keep this in mind. You're trying to understand the employee limitations. You don't want the full medical diagnosis. You just want to work with that employee to find out what they can do and help them get back to work, right? You want to fulfill your obligations as the employer. And when you talk with if you should call the physician's office, that's what those words should be used. I'm trying to fulfill my obligations as an employer with this employee.
I often have the problem because a lot of the employees is dealing with taking care of their family members overseas. Sometimes they cannot provide good
Certification.
and they maybe just get some foreign language, something without that's chosen. It's hard.
Yeah, that does get very, very complicated. And there is further guidance in FMLA when that occurs. So if it's not in here, we'll get you that. But there is more guidance in there. Okay. Let's see. Go to that next paragraph there. The requirements of HIPAA, which govern the privacy created or held by those entities, must be satisfied when individually identified health information is shared with the HIPAA-covered healthcare provider. The last sentence of that paragraph, the second line from the bottom, halfway across, it is the employee's responsibility to provide the employer with a complete and sufficient certification and to clarify the certification. Again, if they do not, they're endangering their FMLA rights. Okay? All right, next page, second opinion. If an employer has reason to doubt the validity of a certification, the employer may require the employee to obtain a second opinion at the employer's expense. Pending receipt of the second medical opinion, the employee is provisionally entitled to benefits of FMLA. So, you know, Ashley works for me and she brings me back this certification. I'm like going, I don't really want to get a second opinion. I'm going to pay for a second opinion. So I'm going to go to Dr. Foley, and Dr. Foley is going to give me a second opinion. But in the meantime, I have to give Ashley full FMLA rights. I have to under that obligation. Even though I'm not really confident that it's legit, that's my obligation.
You can choose where you get that second opinion from?
Yes, as long as, and it gave you some guidance as to the, it can be, if it's not in here, it does tell us that it's who that physician can be. You can, as the employer, select that physician.
Is it normally best in that situation to use a physician from your panel, workers' comp panel or not?
You know what? That's going to be up to you. There's no reference in here as to whether that's, you know, a good idea.
It says that it can be.
The next paragraph, right? Yeah. Let's go ahead and read that. An employer is permitted to designate the healthcare provider to furnish the second opinion, but the selected healthcare provider may not be employed. Well, great, they're not on your payroll. The employer may not regularly contract with or otherwise regularly utilize. So if you're on your panel, that to me that's a pretty regular utilization.
Yes.
Okay? So that kind of answers it for us. Okay, but it does say that it may be limited if you're like in a rural area, and that's understandable. Okay. What about second opinion comes back? I don't want Dr. Foley's opinion, so now I'm going to go to, you know, Dr. Smith and say, now I want a third opinion. If the second opinion differs from the first, the employer may require the employee to obtain certification from a third healthcare provider, again at the employer's expense. This third opinion is final and binding. You're done. 3 times, hey, you know, you're done. Final and binding. What about copies? That next section, the employer is required to provide the employee with a copy of the second and third medical opinion where applicable upon request. So if they ask you for it as an employee, as the employer, you have to give it to them. Requested copies are to be provided within 5 days. Yes, ma'am.
Now, what if the employee doesn't like what the second opinion says? Does that matter?
Well, I mean, you've got a second opinion, and if it's converse to the first one, that may be a situation where you decided to get a third opinion. I'm just not sure how many of us, you know, how involved in this do you want to get? If it's, you know, up to you to make that decision, you feel like it's important, you have that right, you know, to follow this process. Okay. Travel expenses, if the employer requires the employee to obtain either a second or third opinion, the employer must reimburse an employee or family member for any reasonable out-of-pocket travel expenses to get that second or third opinion. Okay? Recertification. Generally, an employer may request recertification no more than every 30 days and only in connection with an absence by the employee. However, an employer may request recertification in less than 30 days if they want more time, the employer requests an extension of leave, the circumstances have changed, for example, the duration or frequency of the absence, the nature of the severity. Okay? What about the third one there? The employer receives information that casts doubt on the employee's stated reason for the absence. Okay? So Eric goes out on FMLA leave, and he's hurt his back, and he says, I can't get out of bed, I can't come in. The next day, I'm trying to read him too far away, Jesse sees him on the golf course with his buddies. Would I have reason as the employer to doubt the validity of his request? What a nice backswing and, you know, straight and long. Absolutely, I would have every right. So I need to reconfirm that certification. Okay, then the next full paragraph below that, about halfway down, see fifth line, wait 40 days, keep going. In all cases, an employer may request a recertification of medical condition every 6 months, okay, in connection with an absence by an employee. The bottom of that page starts going into qualified exigency. The one thing I want to point out here is if you flip the page, go down, let me read the first sentence. The first time an employee requests leave because of an exigency arising out of active duty or call of active duty status of a service member, an employer may require the employee to provide a copy of the orders, the active duty copies, or active duty orders, excuse me. And then about 3 lines down, go toward the right. This information need only be provided to the employer once. So if you've gotten it once, you've gotten it. All right, again, protections of the military. Toward the bottom, verification. If an employee submits a complete and sufficient certification to support the request for leave because of an exigency, the employer may not request additional information. You do not get second and third opinions if you're in the military. Okay? You don't, it doesn't happen. All right, go 1, 2, 3 pages over, and it'll say intent to return to work and fitness for duty certification. Who in here requires fitness for duty certification? Do you know if you do? You do it? Okay. Anybody else?
You mean return to work notification?
Yeah, what did I say? Fitness for duty? It's a, yeah, return to work, fitness for duty. Okay. This is allowable as a condition of restoring an employee whose FMLA leave was occasioned by the employee's own serious health condition that made the employee unable to perform the job. An employer may have a uniformly applied, I think that's the key word, uniformly applied policy or practice, okay? Next paragraph, an employer may seek a fitness for duty certification only with regard to the particular health condition that caused the FMLA. So you just don't want to get more information than what you need, and it's only related to that FMLA absence, right? Go to the next page, the first full paragraph. The cost of the certification is borne by the employee, and the employee is not entitled to be paid for the time or travel cost spent in acquiring the certification. The designation notice must advise the employee if the employer will require a fitness for duty certification. We'll look at that designation notice here in a minute. It talks about reasonable safety concerns. Go ahead and turn the page about halfway down. Failure to provide certification. In the case of foreseeable leave, if an employee fails to provide certification in a timely manner, the employer may deny the leave until the certification is provided. Okay? So it talks about unforeseeables. Flip the page, go to review. Go to number 2 there. Employers must provide written notice detailing employees' obligations under the FMLA, including their need to furnish certification. We'll see those certifications in just a moment. Number 11, that talks to recertification every 30 days. The next page, number 13, If an employee gives unequivocal notice of intent not to return to work, the employer's obligations under FMLA to maintain health benefits subject to COBRA and to restore the employee cease. Okay, I am not coming back. I have had this child. I want to stay home with my child and raise my family. I'm not coming back to work. Okay. But I had dental before I went out on FMLA to have my child. Do I get dental COBRA? Absolutely. Okay. If I had medical and vision as well, then I would have the rights to cover for that as well. But once you've exhausted those 12 weeks, or if you're just, even if it's not exhausted, and the employee says, I'm not coming back, then it triggers COBRA. Does that make sense? Okay, all right. I'm sorry, number 16, fitness for duty reports may require nothing more than a simple statement of the employee's ability to return to work. So, next page, employer duties. We're going to talk about the general notice and the employee handbook. All right, there's a couple things I want to do here. We're going to see how good our dexterity is, all right? Put your hand there and flip to the very last tab that says Timeline Checklist. Timeline Checklist. Okay, this is what I'll call the old-fashioned flow chart that I built to kind of take you through the process because there's so many steps with FMLA. I hope it's helpful for you. On the left-hand side, you'll see a column that says the time period. On the middle section, you've got the notices listed, and on the right-hand section, it tells you the regulation reference for that certification or paper, okay? So at pre-hire, you're going to have your poster with the FMLA notice on it, right? So that's for everyone, continual. At point of hire, you're going to provide the notice to the new hire or included in the handbook, okay? So for that, you're going to use the WHD publication 1420. So you've got your poster. You could put in your handbook this 1420. So flip back and go, all right, let me count my pages. 1, 2, 3, 4, 5, 6, 7. Oh my goodness, it's about, oh wait, you know what, did I have that? No, it should be in there. In the same section where it's about 16 pages forward, and it's going to look like this. Employee rights and responsibilities, that's your WHD 1420. All right, since your page is numbered to the print, I apologize. That's what it looks like. That's your WHD 1420. Have you seen this before? Okay. So you could actually take this. I mean, this prints off right from the DOL site and put this in your employee handbook, just like this. Okay.
Can you say it again?
WHD 1420. Okay. Okay. So go back to your timeline in the back. And then it says, after 12 months and 1250 hours, the employee requests foreseeable leave, or they're out for unforeseeable leave. Within 5 business days, you notify the employee of their eligibility and their responsibility, and you use the 381. Okay, that's your notice of eligibility and rights. Your 381 was on your table in front of you when you come into the room. It was a 2-page document. It looks like this. Notice of eligibility and rights and responsibilities. That was a 2-page document. Okay. If you want to, you can put it in your binder right after your WHD 1420. It's up to you, but that's the document I'm referring to. Okay? Go back to your timeline. Then you give the employee the requested certification form, and that's where you're going to say, I understand that you want it, I've given you your rights, now I'm giving you the form to get to your doctor, whether it's for you, a family member, or what have you. And that's all those forms listed below, and we'll look at those in just a moment, the 385, et cetera. Then within 15 days, they have to give you that form back. Again, how many days for them to cure any deficiencies? Remember, 7 days, right? Within 5 business days, the employer notifies that the leave is not FMLA. That's when you use the 382 designation notice. And then, after 12 weeks or continuous or intermittent, that's the code trigger. Does that make sense? Just kind of like a timeline of events. I just find it helpful to, I guess, a visual person to see how it all falls together. Okay. All right, so know that that's there under your timeline. Now let's go back to the general notice page. Under employer's duties, general notice, where we were. Every employer covered by FMLA is required to post and keep posted that 1420. Employee handbooks. If an FMLA employer has any eligible employees, the employer must also provide this general notice to each employee by including the notice in the employee handbook or other written guidance to the employee. And this may also apply to you about halfway through that paragraph, 4 lines down, halfway across. Where an employer's workforce is comprised of a significant portion of workers who are not literate in English, the employer must provide the general notice in the language in which the employee is literate. So do they speak English or no? Some? Limited? Okay, all right. Do y'all have bilingual? Do we have a lot of languages spoken in the workplace? Absolutely, okay.
And Carmen, I spoke with an attorney regarding, because when I first started, we had a bunch of people that were taking vacation using FMLA to go out of the country. And the attorney stated that really, as an employer, you're kind of stuck. The only thing you really can require them to do if they say they have to take care of a family member is to make sure that their information is in English. It's up to them to pay for the translation and make sure all the documentation is to where the employer can understand it. And then that's basically it. You're kind of stuck.
It is what it is. Yeah. Okay. The risk management phenomenon here, the thing to remember is, have your poster up. You're going to give them the notice and put it in the handbook. You could do all 3 of those, and that's the best way of communicating. I know is just tell and tell again, right? Okay, so let's go 1, 2, 3, 4 pages over to where it says eligibility notice is your first subhead, eligibility notice. Okay. When an employee requests FMLA leave or when the employer acquires knowledge that the employee's leave may be for an FMLA qualifying reason, the employer must notify the employee of the eligibility to take the leave. The notice must be given within 5 business days, absent extenuating circumstances. So there's your time frame there. Then your rights and responsibilities notice toward the bottom of that page. Under the FMLA, covered employers must provide written notice detailing specific expectations and obligations of the employee and explaining any consequences of a failure to meet those obligations. And that's your rights and responsibilities notice. Designation notice is on the next page. Employers are responsible for designating leave as FMLA qualifying and for giving notice of the designation to the employee. When the employer has enough information to determine whether leave is being taken for FMLA qualifying reason, for example, after receiving the certification, the employer must notify the employee whether the leave will be designated and will be counted as FMLA within 5 business days. Only 1 notice of designation is required for each FMLA qualifying reason per applicable 12-month period. Okay, so it's 1 notice for each type of leave, for each leave requested. Is it common for you guys to have multiple FMLA leave reasons within a year, or does it tend to be the same recurring reason? What are your experiences? Same, I would think it would be much more common.
We just had a situation that was very interesting. We had a young man that got hurt at home, hurt his hand, he took some time off at FMLA because he had to get surgery on this. Then he had a workers' comp claim on his shoulder. Then we really got into this whole rolling calendar thing. right when the email came out, yes, I'm coming, that kind of situation. So yeah, that's really, really, really tricky, trying to make sure that he didn't go out, and then once he exhausted his 12 months, his 12 weeks of leave, what's next for him, that kind of thing. So yeah, and that's not a very common occurrence with us, but it just so happened to fall like that.
Yeah. And you were smart to pick up on the fact that, you know, it wasn't just one or the other. That whatever is a serious health condition is going to be FMLA. So, okay. So that's your designation notice. Let's see. If you flip one page, if you're actually in this document at the bottom of our resource, Think HR, these are links that take you directly to those forms. The next page, updated forms and notices. I do want to make sure we get this point communicated well. The second full paragraph, the updated forms do not include the safe harbor language recommended by the EEOC regulations to prevent the disclosure of genetic information as prohibited by GINA. Consequently, regardless of whether the employers use the DOL forms or their own, they should always add the following language in request for employee health-related information in compliance with GINA. The Genetic Information Act of 2008 prohibits employers and other entities covered by GINA Title II from requesting or requiring genetic information of any individual family member of the individual except as specifically allowed by this law. To comply with this law, we are asking that you provide any genetic information, do not provide any genetic information when responding to this request for medical information. And then it goes on to give that definition, any family medical history, results of genetic tests, family member sought or received genetic services, genetic information of fetus carried, or embryo, etc. So the point is they're saying, hey, this should be on the forms and it's not. It was an oversight when the forms were issued. So what are some ways you could get this information onto the forms? Any ideas?
Separate page or included as part of the employee handbook.
Yeah, put it on the handbook, or I think putting it as part of the actual form would be smart. Just kind of copy and pasting, you know, onto a piece of paper. Boom, there it is. You know, so they're actually here's the suggested wording for that. Toward the bottom, employee duties, notice for foreseeable FMLA leave. The employee must provide the employer at least 30 days advance notice before FMLA leave is to begin. To me, you know, it seems like 80–90% are unforeseeable, right? Isn't that what we hear more than anything? It's like, or they're gone and you're wondering, where are they? And then that's where you have to think about, did the supervisor even know what to look for so that they knew it was FMLA? Am I the only one who hears problems with communication? No. I mean, it's just the supervisors don't understand that it's a huge liability. They have to be able to recognize and communicate to you what is FMLA leave, right? So, you know, there may be instances where training is in order, and there are really only about 3 or 4 regulations that you need to hit on. And once they hear the word liability, it tends to get their attention, right? They are personally liable. Okay, that's huge. So most of the human resource managers I've worked with say, look, I just want them to tell me. I'll handle it, right? They just need to recognize what it is and they know when to bring it into the picture. I don't want them doing it because they don't have time for that. They're not HR managers, right? But training is a big deal. And so if you haven't done FMLA supervisor training, that's probably something you want to think about and do this coming year. Really, really helpful. The next page, if 30 days notice is not practicable, such as because of a lack of knowledge of approximately when leave will be required, a change in circumstances, or a medical emergency, notice must be given as soon as practicable. As soon as practical means as soon as both possible and practical, taking into account all the facts and circumstances of the individual case. Okay. The content of the notice, about 3 paragraphs down, an employee must provide at the minimum verbal notice sufficient to make the employer aware that the employee needs FMLA qualifying leave and the anticipated timing and duration. If the employee says, I can't stand, I know I'm supposed to stand, I can't do it, I can't come to work, they're giving notice. They don't have to use the words or the letters FMLA. They're giving you notice, or the manager, as it may be. Okay, toward the bottom, below those bullet points, you might want to put a big star here. When an employee seeks leave for the first time for an FMLA qualifying reason, the employee need not assert their rights. That's exactly what we were just talking about, or even mention the FMLA. When an employee seeks leave due to that qualifying reason for which the employer has previously provided the protected leave, the employee must specifically reference the qualifying reason or the need for leave. So, if it's recurring and they say it again, then it's going to be another instance under FMLA, right? But they've already told you. So, but if the first time they just say, I can't do my job, then you might want to ask another question. And those questions we talked about earlier is what kind of asking to see that it is FMLA, right? Toward the bottom there, if you go about 5 lines from the bottom toward the right where it says when an employee has been previously certified for leave due to more than one FMLA reason, the employer may need to inquire further to determine which qualifying reason the leave is needed for. An employee has an obligation to respond to the employer's questions designed to determine whether an absence is potentially FMLA qualifying. Now, in the past, I think there's been some gray area as to whether or not they wanted to use their FMLA. Oh, I don't want to use my FMLA for this. I just need to be out. If it's FMLA, it's FMLA. You know, the old saying, if it walks like a duck, squawks like a duck, talks like it's FMLA, right? It's a duck, it's FMLA. So I'd be really, really careful to stand your ground if you want to say, look, I have to designate it. It's my obligation as the employer. It's qualifying. Okay. Then you get into the entire consistency problem as well. Let's see, next page. What about scheduling medical treatment? Go to that second paragraph. An employee must advise the employer upon request of the reasons why the intermittent or reduced leave is necessary and of the schedule for the treatment, if applicable. And the employee and employer must attempt to work out a schedule for such a leave that meets the employee's needs without unduly disrupting the employer's operations, so to the approval of the healthcare provider. So the point here is that the employee should work with you, if possible, to work out a schedule so that their work still gets done. Okay, that's the whole gist of it here.
One question. I currently have one employee, it's first stage cancer, so all the appointment, whatever, it's fine. But constantly in the morning, he comes late. I don't feel comfortable. Is that treated as a FMLA?
Well, then you've got to go back to your serious health conditions and see if he qualifies. Read through, because that's definitely a serious illness. It's just his instances, his treatment by his doctor, how many times is he seeing his doctor, and it's a high likelihood it's probably going to be in a intermittent leave, and that should be, okay? Absolutely. The forms now are much better than they used to be in qualifying when it is FMLA, and they ask the doctor a lot more about that condition, like is the employee expected to be out a certain amount of time. They ask for a lot more information than in the past. They are better than they were initially. I know they're still not great, but they are better. What about notice of unforeseeable leave? Go to that section about the 5th line down. Notice may be given. Notice may be given by the employee's spokesperson, for example, the spouse, the adult family member, or other responsible party, if the employee is unable to do so personally. So it does not have to be the employee. They can have someone call in for them, contact you. Continue that paragraph about the 3rd line from the bottom toward the right. However, if the child's asthma attack required only the use of an inhaler at home followed by a period of rest, the employee would be expected to call the employer promptly after ensuring the child has used the inhaler. So if you go back to that example, let's go back up, that was a little disjointed. I'm going to go back up to 3 or 4 lines, and toward the right it says 4. Let's read that example. For example, if a employee's child has a severe asthma attack and the employee takes the child to the emergency room, the employee would not be required to leave his or her child in order to report the absence while the child is receiving emergency treatment. Well, that makes sense. They're going to stay with their child while the child's being cared for. But, in other words, once they get the child stable, now the employee needs to contact you because the child is no longer a threat, right? So what's reasonable? What is reasonable? Just use some good common sense there. Content of the notice. Okay, let's flip the page and go to the second full paragraph. Calling in sick without providing information will not be considered sufficient to trigger an employer's obligations under the FMLA. Thank goodness that that's clear, right? The employer will be expected to obtain any additional required information through informal means. An employee has an obligation to respond to an employer's questions designed to determine whether the absence is potentially FMLA qualifying. Failure to respond to reasonable employer inquiries regarding the leave request may result in the denial of the FMLA protection if the employer is unable to determine whether the leave is FMLA qualifying. So again, if they don't respond and you said, I need this information, and you're following those time frames, then that's the point where you need that discussion with the employee and say, please understand, I'm trying to follow the provisions of the law. This is for your benefit. It is job protected leave. If you're not going to follow the law, you have no more protections under FMLA. And then you resort to, let's talk about performance, right? Because now they don't have that job protected leave. If there's a disciplinary action, if there's an attendance problem, if there's something that work is not getting done, then they are not fulfilling their obligations in that capacity as an employee in that job. That's only if you've been able to separate, FMLA and they no longer have those protections. Okay? So, got to be careful, but yet there is a recourse, so to speak, for the employer if the employee is not cooperating. Okay, go 2 pages over to foreseeable leave. And this just again repeats that it's much stronger for the employer now. Let's see. Okay, next page. This is important. Retroactive designation. Go about 2/3 of the way down. This happens a lot, because employees are out, and then you find out later who actually was FMLA qualifying, right? If an employer does not designate leave, the employer may retroactively designate leave as FMLA leave with appropriate notice to the employee, provided that the employer's failure to timely designate the leave does not cause harm or injury to the employee. So let's think about that. They're saying you can designate FMLA leave after that leave has occurred, as long as it doesn't cause harm or, the protections, the rights of that employee are affected. From a risk management perspective, you want to be really careful with that. Let me see if I can kind of give you an example. If an employer did not tell, again, in this case, let's use the female again, like we did just a few moments ago with the maternity leave and the work comp leave. If the employee did not tell a female employee that the leave of 3 weeks was counted toward her FMLA, and later she wants to take her full 12 weeks, would that be harmful to the employee? Yeah, I had the right to designate those 3 weeks retroactively, but I didn't tell her, and now she wants her 12 weeks. That's harmful. So be very careful with that retroactive designation. Okay. What about remedies there at the bottom? If an employer's failure to timely designate leave causes an employee to suffer harm, it may constitute an interference with, restraint of, denial of, and exercise an employee's rights. An employer may be liable for the following: compensation of benefits lost by reason of violation, actual monetary losses sustained as a direct result of the violation, and appropriate equitable or other relief including employment, reinstatement, promotion, or relief tailored to the harm suffered. Now that sounds to me like legalese, that an attorney could easily say, we think she or he should get X. Okay, it's tailored to the amount of the suffering that this employee endured. So let's look at review. Number 1, employers must post a notice listing FMLA rights in a place where the employees and applicants will see it. even at work sites where there's no eligible employees. Number 3, employers must ensure that FMLA information is included in handbooks or other written material. So even if you don't have a handbook, you still have to get this policy out to employees. After the handbook. Let's hope we all have some form of handbook. But handbooks are not required. It's really not required, but your FMLA notice is. So that's the bottom line. Look at number 12, there toward the bottom of the page. If there is a dispute between an employer and an employee as to whether leave qualifies as FMLA, it should be resolved through discussions. There's that interactive process, just like you're going to want to have with the ADA, right? Number 13, in certain circumstances, an employer may retroactively designate leave as FMLA leave with appropriate notice to the employee, provided the employer's failure to timely designate leave does not cause harm or injury to the employee. Okay. All right, so the next thing in your page, or in your book rather, is that your WH 1420? Yeah, okay. Or it might be your notice of eligibility, depending on where you put that. So that's your poster that can go both on your wall or can go in your handbook. And then you have your notice of rights and responsibilities. Then you have certification of healthcare provider for the employee's serious health condition. Are we there? 380E at the bottom, 380E. Okay, so I just wanted to kind of refresh our memories to what's on these forms because they really are pretty good. It talks first in section 1 to the employer, kind of gives you what the regulations say, and it asks you for their essential job functions. So again, that job description would come in handy. Then it says, check if a job description is attached. Not a bad idea. Not a bad idea at all from a risk standpoint. Section 2, for completion by the employee, their name. Section 3, that's what the healthcare provider fills out. If you look at that paragraph talking to the healthcare provider about the 4th line down, halfway across, be as specific as you can. Terms such as lifetime, unknown, or indeterminate may not be sufficient. So they're telling the doctor, please be specific, I need your help. You want as much as possible for that physician to make the call. You want him or her to make it as easy as possible for you to designate, right? Okay. I had a call from an employer earlier this week where they had an employee who had a condition. It's a common medical condition. Actually, it's lupus. And because of her condition, her doctor had told her that she could only work 2 days at a time, and she needed 3 days off to follow that to recuperate. And I had not heard of that, but apparently her body's chemistry is such that 3 days off allows her time to recuperate, and then she can be exposed again to it. So that really was not so much an FMLA instance as it was an ADA instance, because by allowing her that flexible schedule, that was their accommodation for her. Okay. So you may have similar circumstances. The concern was, but what about her salary? You know, what do we do about her pay? And that got into another discussion I won't go into here, but my point is that, you know, for that employee, it may be an instance where she may want to find another profession if in fact there's nothing that can be done about her condition. And it is a lifelong, you know, chronic condition. I found that was interesting. All right, so your form there, the next page goes on to medical facts. Look at everything that's asked on here. The date it commenced, how long is it going to last? The date you treated the patient. Will the patient need to have treatment visits twice per year? What about something other than over-the-counter medication? Were they referred to someone else? Is it pregnancy? And then use the information provided in section 1 to answer the following. Is the employee unable to perform his or her job functions due to the condition? If so, which functions can he or she not do? I mean, it's very, very specific when you think about it, okay? Describe other relevant medical facts. Then the next page asks the physician, how much time will they need? Will the employee be incapacitated for a single continuous period? Will they need to attend follow-up treatments or work part-time? Number 7, will the condition cause episodic flare-ups? And then below there, what's the frequency? Give us more information. Then the next page is basically blank lines. And the doctor signs it, of course, so no one can read it. But signs and dates that, and that's your employee form. It's very similar with the family form. It's going to follow very much the same format. And that follows your next, I think, 4 pages as well. Then you should get to certification for qualifying exigency for military leave. I think that's your next form. Okay.
Is this the 385?
It is, yes, I believe, hang on, and I don't know why they didn't put the form number on it, on the actual form, just to confuse us probably. Let's go back to my cheat sheet, my timeline. Yes, certification for serious injury or illness for a covered service member for military family leave, or military, family leave, that's 385. Okay, so they attach a copy of the active duty orders, qualifying reason on the 2nd page, amount of leave needed, and then what about the last part C on the next page is if they're going to meet with somebody else, who you're going to meet with, that kind of thing. Then the next one is your certification for serious injury or illness of a current service member, and that is that's your, wait a minute, your exigency, was that the exigency, the one we just looked at? All right, exigency is 384, excuse me. Exigency, that is the weirdest word and difficult for me to say. Exigency is 384, and then the serious injury, which is your caregiver form, is 385. So there's 1-digit difference there. I apologize that it is on the form. The very bottom right does say 385 on the caregiver form. The certification for serious injury or illness for a current service member. Again, this is an employee that's going to be taking care of someone who's been injured, okay? And then on that first page for the 385, go about halfway down, it says instructions to the healthcare provider. The employee listed on page 2 has requested leave under FMLA to care for a family member who's a current member of the regular armed forces, the National Guard, or the reserves. So it's telling basically the purpose of the form. Okay? Then we go on to 4 pages forward, and you get the last form that's just recently added. The bottom right corner says 385V as in veteran. This happened in 2013. That was the effective date for veterans. And here's kind of the overview. Under the final rule, an eligible employee may now take FMLA military caregiver leave to provide care for a family member who is a veteran discharged from the military within the last 5 years. To qualify, the veteran's serious illness or injury must have occurred or been aggravated while the veteran was on active duty, although such an injury or illness that first manifests itself after the veteran leaves active duty is also covered by the final rule. Let's see. So that was an update since 2009. That was 2013. So that veterans have that coverage as well. Okay. Okay. So that is the 2 pages there. Actually, let's see, 3 and 4 and 5. The next form in your booklet should be the designation notice, and that is the 382, WH 382. And this is where, after the certification comes back to you, that you respond by giving this back to the employee saying, yes, I'm designating it as FMLA. Okay. It says there, the first section above one of those bold lines, we reviewed your request for leave under the FMLA and any supporting documentation that you provided. We received your most recent information on blank, and then your FMLA is approved. All leave taken for this reason will be designated. And then it goes on to say, we need to know if you have any changes. If it is not approved, there is a, go toward the bottom, about an inch below the bottom. Your FMLA leave is not approved. Your FMLA does not apply to your leave request. You have exhausted your leave entitlement. You know, whatever it is you want to communicate back with them, you just indicated at that point on the designation notice. That's just a one-page form. Okay. The next section in your book is the military caregiver leave. In addition to the qualifying exigency leave, recent amendments to the FMLA provide for military caregiver leave. Under the caregiver leave provisions, eligible employees are entitled to leave to care for a spouse, a parent, a son, a daughter, or an extra kin. Okay. The next page tells you what is next of kin. It's very specific as to a blood relative. A blood relative is in granted legal custody, brothers, sisters, grandparents, aunts, uncles, first cousins. It's pretty lengthy. There are certain employers that tend to hire within family relationships. This could get to be quite cumbersome. You know, quite frankly, there could be a lot of leave if you've got, particularly in rural areas, you see a lot. That may be the only production facility out there, and so you've got cousins, brothers, you know, it's going to happen. So if they've been in the military, you know, it can be pretty hurtful to the workforce, if you will, when the absences are there. Toward the bottom, the length of leave, unlike the other types of FMLA leave, which entitle eligible employees to 12 weeks of leave, the covered service member leave provisions entitle the eligible employee to take up to how many?
26.
26. So it's basically, what, a half a year? 26 weeks of leave during a single 12-month period. Okay. Go over to the next page. What if they have both regular FMLA and this leave as well? Combining leave. An eligible employee is entitled to a combined total of 26 work weeks. That's their max. Okay. For any FMLA qualifying reason during a single 12-month period. Provided the employee is entitled to more than 12 weeks for one of the reasons below. So the only instance for 26 weeks is your military caregiver. Everything else is just 12 weeks. But they do have a max of 26. Small amount of time, right? So that is your military. Go on to your next tab, which is policies. And in here, we've given you a couple of templates. The first one is, I guess I could say, more your family medical leave policy that lasts, let's see, 1, 2, 3, 4, 5 pages. If you flip on over, your next one is your military family and qualified exigency leave policy. Okay? So just some policies that you can look at. It's pretty clear what's in here. If you have any need for either of those, let us know. Okay? Your next tab is your DOL employer responsibilities. Employee protections. And this is the kind of material that you would want to use when you're talking to your employees for supervisor training. And Jared and I can do the supervisor training as well. We've done that also. If you go about right below your bullet points, any violations of the FMLA or its corresponding regulations constitute interfering with, restraining, or denying the exercise of rights. The employer may be liable for compensation and benefits lost, monetary losses, and those other equitable forms we talked about earlier, employment reinstatement, etc. It gives you some examples about what is interfering with the exercise of those rights. Look at those bullet points. Transferring employees from one work site to another for the purpose of reducing work sites, just those laws that we talked about when we were drawing our maps on the geography. Changing the essential functions of the job in order to preclude the taking of the leave. Reducing hours available to work in order to avoid employee eligibility. The next page on, in that section, waiver, and this is really important too, there's actually been case law on this. Employees cannot waive, nor may employers entice employees to waive their prospective rights under the FMLA. Okay, so they cannot be waived. There was actually a case in, it was the Fourth Circuit. Barbara Taylor, after exercising FMLA rights, was laid off as a part of reduction in force. In exchange for an enhanced severance package, Ms. Taylor signed a general release waiving her right to sue under various federal laws. Subsequently, she sued, claiming her layoff was in retaliation for her FMLA leave. The company argued that the voluntary release barred her from bringing suit, and the Court of Appeals found that the DOL regs provide that the employees cannot waive, or employers induce employees to waive their rights. So that's actually been tried. Okay, go to the next page, Department of Labor's role. And it tells you here, for those bullet points about in the middle of the page, the following are examples of conduct that can give rise to employee complaints. The employer fails to notify them of their rights, to notify employee the employee's leave counted toward, I didn't tell you, and now I am telling you, the leave. The third one, the employer counts leave under the absentee policy for disciplinary purposes. Cannot do that. Remember, it's job protected. You can't count it against their performance. Employer takes action against the employee for using the leave, fails to grant the leave to provide physical or psychological comfort to a seriously ill parent or spouse, fails to reinstate the employee to the same or equivalent position, terminates an employee during or at the conclusion of leave. I cannot tell you how many times I've been asked, I'm sure Jared has too, we have this employee out for FMLA. It happened just yesterday. Have this employee out for FMLA leave. They're really not a good worker, and they're very disruptive. They're very loud. They're not a good worker. The performance comes so-so, and they want to come back from their leave. Can't we just terminate them? And it was clearly FMLA leave on record. What would you do? Gotta bring them back. Job protection, protected leave. I just want to terminate it. Well, you know, bring them back, then let's talk about what can happen, you know, with interaction with that employee and documenting. But unfortunately, sometimes those performance issues kind of go hand in hand with someone who's out a lot, right? And so FMLA comes into play as well. Okay, and then you have some other conditions there in that same section. The certification wasn't done properly. The employer fails to obtain medical information or certifications according to the regs. And then the next page talks to damages. I think we've talked about that. It's pretty expensive. The next page, the review. Number 1, it is illegal for employers to interfere with exercise any right. Number 7, an eligible employee may bring a private suit against an employer for violating the FMLA without filing a complaint at the Wage and Hour Division. Interesting. Number 10, FMLA protection is not available to shield employees from excessive absenteeism caused by non-FMLA leave. So that's when knowing what's going on is important. The next page, I put this in here just because I thought it was pretty educational. These are some frequently asked questions to kind of help you through. Go to number, it's not numbered, I'm sorry, but the 4th one down. Does workers' compensation leave count against the employee's FMLA leave entitlement? It can. Does it happen every time? Probably not. FMLA leave and work comp can run together, provided the reason for the absence is due to a qualifying serious illness or injury, and the employer properly notifies the employee in writing that it's FMLA. 2 down, 2 questions down, can the employer count time of maternity leave or pregnancy disability as leave? Yes. The next question, if an employer fails to tell employees that it's FMLA, can the employer count the time already off against the 12 weeks? In most situations, the employer cannot count leave as FMLA leave retroactively. That's kind of an interesting answer. In most situations, remember, the The employee must be notified in writing that the absence is being designated as FMLA. If the employer was not aware of the reason, leave may be designated as FMLA retroactively only while the leave is in progress or within 2 business days of the employee's return to work. So it's not just a license because the law changed. You've got to be very careful with that. Flip 2 pages over, look at the first full question. Can an employer make inquiries about the employee's leave during the employee's absence? Yes, but only to the employee. We talked about some time frames there. Go down 3 questions, about 2/3 of the way down. Are there other circumstances in which the employer can deny an employee FMLA leave or reinstatement to the employee's job? In addition to denying reinstatement in certain instances of key employees, employers are not required to continue FMLA benefits or reinstate employees who would have been laid off or otherwise had their employment terminated if they had continued to work. The next paragraph, employees who have unequivocal notice that they do not intend to work will lose their FMLA, intend to return to work will lose their FMLA. Next paragraph, employees who are unable to return to work and have exhausted their 12 weeks of FMLA leave in the designated 12-month period no longer have FMLA protections. And in the last paragraph, under certain circumstances, employers who advise employees experience a serious health condition that they will require a medical certificate of fitness of duty to return to work may deny reinstatement to an employee who fails to provide certification or may delay reinstatement until you get the certification. Okay? Okay, the very last question on the next page. Can an employer count FMLA leave against a no-fault absenteeism policy? No. Okay, so be very careful with that one too, because I've seen that in a lot of handbooks and it can get very dicey. Okay, I know that most attorneys do not like the no-fault attendance policy. So your last section in here is your overview. There's your timeline. If you want a more explicit timeline, if you flip 1 page, this FMLA administrative checklist gives you a real breakout of the steps of the process. So if you need something more specific, you would go there. And then if you go farther, you'll see that definition of parent that we talked about earlier. The next one's a military, regulation in 2008, and then the last one is that locus parentis, the last 3 pages of that section. Okay. So let's just kind of wrap it up here with, okay, so what do we do from the standpoint of, what are some things we can remember from a risk management standpoint? Recognize that FMLA leave is not just for maternity leave. It is so much more than maternity. We've seen that, right? For comp, other forms of disability, other reasons for FMLA. Be sure FMLA absences are not considered in performance evaluations. The law is pretty explicit about that. They are protected. Review your FMLA policy for completeness and updating. Do you have the military language in there? Are there some things in there that you're not following in practice that you want to change in your FMLA policy? Know and enforce consistently timeliness and calendars. All right, so look at your timeline there in your last tab and look at your checklist. Hold periodic supervisor training on FMLA using the 4 key regulations, so that your managers know to see you when someone's not there, to see if it is FMLA. Integrate workers' comp, ADA, and FMLA. And of course, I could add that, of course, disability. Review state laws for greater protections than the FMLA, because you could have some that are more generous. Check your practices for needed procedures and better communication between human resource and supervisors, right? That the whole full circle thing. And I believe that concludes our techniques. All right. I think that's it, guys. Do we have, I can wrap this this up here with just a few things, and then I'll let you out of here as close as I can to the time we designated. Your feedback forms, we really do solicit those. If you've got a minute, then you can complete those feedback forms. If you need something, need explanation, just let us know. Your certificates, we have those, and we'll have pomp and circumstance playing in the background as you exit. So you're now all experts, right? This is our last workshop for 2014. If you've come before, I hope they've been beneficial and helpful. We intend to continue these in 2015. If there is a topic or something that you would particularly like to see on our calendar, we have a draft of a calendar out for 15, but we haven't fully, put the dates on the calendar yet with a full approval. But please let us know if there's something that would be helpful to you, and we'll see if we can address that in one of our topics for next year. So, anything else from anyone? Everybody's thinking turkey? Okay, everybody have a great Thanksgiving. Thanks for coming.